Freedom of the press in the FRG is increasingly being restricted by the government. Anyone who dares to openly criticize the government as a freelance journalist either gets a visit from special police forces or, as recently happened, is convicted by a German court for lèse-majesté. 7 months in prison on probation. Our donation account at Apolut has been terminated again. We are a thorn in the side of those in power, so we are doing everything right. Journalism is publishing something that others do not want published. Everything else is propaganda. George Orwell. This country is officially being made war-ready, and we are broadcasting against that. Germany must remain capable of peace. Never again war. Our work, funded by a broad community, is committed to this credo. Follow the link Apolut, net/support, and help us, as before, with your standing orders, so that we can ensure independent reporting. Saying what is every day. Apolut.
Welcome to a new edition. Empathy. Welcome to a new edition, Empathy. My guest today, that's right, the female form of guest is Gästin. Check it in the Duden. I just learned that recently, and today it's again about the Fuellmich case. Many of you will know that this case is now almost concluded. Hello, Katja Wörmer. Hello, Rüdiger Lenz. Katja, the verdict has been delivered. Are you going to appeal?
Yes.
Yes, of course, we are going to appeal. So it has already been formally filed. You have to formally file an appeal within a week. And now we have to wait for the written reasons for the judgment. However, that might take a while. We assume that they have already been established for a longer time at the court, but basically they now have at least 5 weeks. Even longer here because we had a very long trial duration. So we have to wait for the written reasons, and only then can we really say more about how we need to proceed here. And then we have to prepare the written appeal justification, for which there is a month available. 3 years, 9 months, and 5 months of pre-trial detention are not credited because, according to the judge, there was a delay in the proceedings caused by your side. What did you think or feel for the first time when you heard that in the courtroom? Yes, well, that's quite intense. We didn't expect anything particularly good, to be honest. So 3 years and 9 months while maintaining the arrest warrant is, however, a bullseye. That is exactly the demand of the prosecution. The prosecution already made their plea last summer. The plea was very, very brief. It lasted barely 10 minutes as far as I remember. And indeed, the entire evidence collection was not considered. It was omitted at that time. They really only focused on the defendant's statement, so they justified it very briefly. And essentially didn't really justify it much at all. They said he transferred the money to a private account, used it for personal purposes, and therefore there was a case of embezzlement. And at that time, the prosecution demanded 3 years and 9 months while maintaining the arrest warrant, and the court has now complied with exactly this demand. That is very unusual. It's surprising, because courts usually regularly fall significantly below the prosecution's demands in criminal proceedings. But in fact, the presiding judge stated in his oral reasoning for the verdict that in his view, there were 2 serious cases of breach of trust. He formed an aggregate sentence. It was once 2 years, 5 months, and once even, I believe, 3 years, 5 months. In any case, he then proceeded to form an aggregate sentence and thereby fully, confirm the prosecution's demand. And additionally, 5 months of pretrial detention are not credited because, as you just mentioned, we, especially the defendant, are accused of delaying the trial according to the words of the presiding judge. So all our defense efforts, all the evidence requests we submitted after the beginning of May last year, The witnesses we partially summoned ourselves and were only allowed to question in a very limited manner. All of this is not classified and evaluated by the chamber as legitimate defense efforts, but really as trial delay. And in this respect, the presiding judge, Judge Schindler, who also delivered the oral reasoning of the verdict, stated that he would particularly accuse the defendant of using the trial as a stage to convey his political messages to his followers and the public, but not to positively convince the chamber of his innocence. And we, the defense attorneys, would have also maintained this in consultation with the defendant, or would have followed this, or would have done this in agreement with him, at least 3 of the defense attorneys. And that is, of course, quite intense. So he literally said that on 24/01/24, the legal view of the chamber should have been clear to us. That was even before the opening of the main hearing. And from that point on, yes, we would have effectively known their legal opinion, although there was another shift, a change at the beginning of May 24. But everything that followed in terms of defense efforts from the defense's side would have been unnecessary from his perspective, and obviously not legitimate either. It must be said that another judge, the associate judge, was also ill for 2 months this winter, and as a result, the whole process was further delayed because there was a 2-month procedural pause.
First of all, I have to say, incredible, unbelievable. How is it going, Reiner? Probably not well. The question is redundant. It certainly won't go well. Is he such a resilient person? He is always brave and full of energy, but did he expect such a severe sentence?
Yes. We both actually expected nothing good from the chamber because the atmosphere in the court had already become very tense. So he was aware that the presiding judge was not personally well disposed towards him. Reiner has also repeatedly appeared very harsh. He didn't appear humble and understanding, and he didn't say something like, yes, I made mistakes, I am guilty, or make any kind of confession. He said, I am innocent. I also represent that view, and I even see something like a perversion of justice in the actions and the assessment of the chamber, especially in the change of the legal evaluation. He presented that very clearly. He also spent the last 2 or 3 weeks writing a plea, which he intends to submit as a criminal complaint to the appropriate authorities. And this kind of behavior usually leads to the court, such a chamber, feeling provoked if the defendant is not understanding. Yes, I'll just say it objectively. Unfortunately, that's how it is in criminal law before our criminal courts. If the judge or the chamber is convinced of the defendant's guilt, while he and his defense believe he is innocent and demand an acquittal, and he also vehemently asserts this, it can simply lead to a very conflict-laden defense, a very tense atmosphere in the courtroom itself, which has been the case here all along, and that this is somehow always considered as an aggravating factor. So it is unfair, but unfortunately that is the reality, and it has been magnified in this particular case. I have not experienced it with such intensity before. That is also extremely rare. So I have spoken with several judges and prosecutors in the background, and the fact that pretrial detention is not credited, even though a judge was ill for an extended period, and the proceedings were prolonged, and then to hold that against the defense and especially the defendant, making it an aggravating factor. That almost never happens. So this is a very, very clear sign that the chamber or the presiding judge obviously felt extremely attacked by the defense and by the manner of Reiner Fuellmich's conduct.
So in total, that's 4 years and 2 months. Overall, when you add the 5 months that are not credited to him, he has received over 4 years of imprisonment or will receive over 4 years.
Yes, I can hardly imagine that this will hold. This will certainly not hold up in an appeal, because the legal requirements for not crediting pretrial detention, even if it happens occasionally, are extremely high. So one must argue extremely well and convincingly in the judgment. We now have to wait for the written judgment's reasoning, but it would also have to hold up in the appeal instance before the Federal Court of Justice, and above all, through another criminal chamber in the further proceedings before the Regional Court. If the appeal is successful, it would be referred back to the Regional Court to a different criminal chamber, and they would have to share the same opinion. So it can be assumed that there will be a different sentence and that they will judge differently. So I can't imagine that, as I said, we have to wait for the written judgment, but I can't imagine that they can justify it so conclusively that it really holds. So, of course, this is being used here as a moment of shock now to really show the defendant that everything he did backfired. So, in the end, this also confirms the political slant of the trial, because one must say there are indeed cases of comparable economic crimes where the perpetrators deliberately and intentionally create fraud. Platforms on the internet, or for example, carry out these grandparent scams, where it's really just about scamming money from people and enriching themselves without any return value. And in those cases, penalties of this magnitude are roughly appropriate. But usually we're talking about clear amounts in the millions. Here we are, clearly below $1 million. We are at $700,000. And we are talking about a loan that he, as he phrased it, and as they exchanged it between themselves here, he and Vivian Fischer, was allowed to use privately. And there was a repayment agreement in the contract. Reiner Fuellmich was willing to repay. The court initially classified it this way as well. They then emphasized both in writing in some decisions during the proceedings and now in the oral judgment that in their view, Reiner Fuellmich was no longer willing to repay since the end of 21, but only to the corporate structure that the court considered relevant here. They regarded these GOG funds as the injured party here, and then said that Reiner Fuellmich no longer wanted to repay these GOG funds. However, that does not mean that Reiner Fuellmich did not want to repay at all. The court did not actually attribute that to him either. They then assumed that he wanted to repay to the UG, which he only founded together with Vivian Fischer afterwards. This UG was founded by the two of them at the end of the year 21 and was also registered in May 22. The donation account of this UG, which then, due to being registered, actually had its own donation account or no longer had to rely on attorney escrow accounts, as was the case with this unregistered Fondsgog, which was originally intended to be founded by 4 people. And just the fact that it is assumed he wanted to repay this new UG together with Vivian Fischer, or that he would eventually return the money. However, ICIC law was only founded in the fall of 22. So he couldn't have planned that back then, at the end of 21. In this respect, this reasoning is also flawed. But these are just corporate law nuances. I can already tell as I'm explaining this now. I can also explain it in more detail shortly. But these are things that the average viewer might not be interested in, because they might say, that's just legal stuff. What do I care? Or these are such subtleties. In corporate law, where you can really say, if I ask 9 lawyers, I'll get 10 opinions, right? The saying is quite well known. So these are really corporate law interpretations. Yes, where you can't precisely say, if he wanted to pay another company, it doesn't necessarily mean that he didn't want to repay the money at all. So to truly accuse someone of intent that they want to personally enrich themselves and really use the money for their private purposes, and then also, yes, want to keep it for themselves privately. That's something completely different from saying, but he then founded a new company with Vivian Fischer because they had long been at odds with the other two partners who were there from the beginning. And that's why he embezzled funds and was no longer willing to repay. So that's a completely different level. And in my opinion, it cannot be legally compared to a truly anti-rule of law attitude, where the only intention is to enrich oneself and harm others. And that's essentially what they're doing here. A differing opinion on corporate law is being interpreted as if he no longer had any intention to repay and had effectively swindled the donors out of their money. Because we, as the defense and also the defendant himself, are clearly of the opinion that this is about the donors. The donors donated the money, and they had no idea whether there was any kind of GAG, whether there was a UG only with Vivian Fischer and Reiner Fuellmich, because at some point only the two of them were appearing. The other two were gone by then, around mid-21, or who was even a shareholder, or if there was even a company at all. No donor knew that. They just donated, and this is also evident from all the transfer slips that we have here in tabular form. They all donated for educational work, for the Corona Committee. From a certain point on, they only saw Vivian Fischer and Reiner Fuellmich as the faces of the Corona Committee. They saw that the two of them were doing the educational work, interviewing people, and the other two were out. They were no longer involved. So how were the people who donated the money supposed to know that they were also donating to Antonia Fischer and Justus Hoffmann, who didn't appear publicly at all anymore and were not involved in the behind-the-scenes work at all? So that's totally, yes, in my opinion, totally fabricated. So...
Yes, constructed.
Pardon?
Constructed. They are constructing something to fit it into the framework of criminality. So I have already talked to you on the phone about this. I also currently have a trial going on for incitement of the people. I don't want to make this the topic now, but what I noticed in this trial is that they did exactly the same thing. So if you look at why I was reported for incitement of the people, anonymously by someone and so on, everyone would say, no, that's not incitement of the people. It's a bit naive, maybe dumb if you can steer it in any direction, but that's all it is. But for example, I listened very carefully to what the prosecutor and the judge did in the trial that I had 3 weeks ago. I think it's been 3 weeks now. And it seemed exactly the same to me, namely constructed. They constructed something and legitimized it with an association about hate speech that exists in Göttingen. Strangely, everything is coming to a head in Göttingen. Yes, in Göttingen, it's somehow like I don't know why. Everything happens in Göttingen, and it's constructed. And the same thing on a much larger scale, much more intense and much more constructed out is what Reiner Fuellmich experienced there. Fuellmich, also what you have experienced as well. Especially since, and this is always the paradox, what confuses me personally completely is the money is there. And the money was already there at the beginning of the trial. So one could have gotten it from someone who has it, but that was refused. The judges refused that. And the second thing is, there was no company in that sense where this process could have taken place, namely the embezzlement of funds in any O corporation. Both of these are completely, and then he can't even make such a judgment. But he did by constructing something and constructing it really heavily. So you have been involved for almost 1.5 years now and have put in an incredible amount of work. I often followed it in the media reports that I received and always thought, wow, that's an intensity. And what you do, what the other lawyers who were occasionally involved have done. So that's an insane amount of work as well. And the dedication, you're really, if I may say so, intertwined with the whole thing. It's somehow become a part of you in a way. And that's already an enormous amount of work that you put into it. And in the end, you get a verdict slapped in your face, where you could also say, I could have done nothing. Then the same verdict would have come.
Yes, precisely.
That's crazy. That's dumb. Well, in my personal opinion, it doesn't have much to do with the rule of law. I just have to say that.
So the way the chairman said it in the oral judgment explanation, one actually got the impression that he and the chamber would have preferred if we had done nothing at all, so to speak. Yes, I thought the same. I wouldn't have needed to work so hard, and neither would the other colleagues, because he clearly stated that from the 24th of January 24, the chamber's legal opinion should have been clear to us. On the 2nd of May 24, they gave us another legal notice. They then said again that in their opinion, the loan agreements were not valid at all. They were void because in reality, it was a matter of a liquidity reserve and purely sham contracts. They concluded this from emails that are now considered as side agreements to the loan contracts, and which were exchanged in November 2020, that is before the loan contracts were concluded. And then there were a few chat messages that were exchanged between Vivian Fischer and Reiner Fuellmich sometime in the summer of 2022, so 1.5 years later. And these emails and chat messages are being used to interpret the loan contracts differently here, to say that they were only concluded as a pretense. And yes, at the latest, since this legal notice on the 2nd of May 24, we should have realized that there was nothing to be done with this chamber, that they could not be convinced. The taking of evidence was then discontinued ex officio. We then had until mid-June to submit evidence requests. We partially met this deadline. But since I was also ill during that time, I submitted additional evidence requests later, and we kept submitting evidence requests because all our evidence requests were actually rejected, initially through 2 evidence rulings. These were then somewhat more detailed. And after that, it was always said that they would be decided in the judgment. So I'm curious to see what happens now. It will probably just be said in general terms that they were submitted too late or were not considered relevant. So I don't expect any substantial reasoning, unfortunately, even though there should be. But we also summoned a whole series of witnesses in the self-loading procedure, for example. This can be done by the defense itself for the defendant at their own expense and with a bailiff. Even these self-summoned witnesses could only be questioned on very specific topics after separate motions for evidence, which we had to submit again. So we had to fight for every question we were allowed to ask them. Mind you, all of this was already in a purely written procedure, so the public was completely excluded. From mid-July, we had to do everything in writing. Then the chamber would always withdraw, read the written motions, come back, say they had read them, and then withdraw again for deliberation. But the trial observers and spectators in the hall didn't notice any of this. The defendant only saw the motions for evidence later on because we had to present them to the court first. And we couldn't always speak to him beforehand since he is in pretrial detention. And yes, then there were discussions about it. Then they were usually rejected or somehow modified. And then we were allowed to ask the present witness 1 or 2 questions, and then it had to be interrupted again. And some witnesses traveled for hours, were there the whole day. And then we sat there for an 8-hour trial day and had about half an hour of proceedings. And otherwise, the whole day was spent discussing, submitting something in writing, waiting again, discussing again, waiting again. And so the trial observers noted down that out of 6 hours of proceedings, only 20 minutes were actually spent on the trial or something like that. And this situation dragged on until mid-November approximately, so over several months. And to then say that we, as the defense and the defendant himself, delayed the proceedings, well, that's quite something, because I think if we could have presented the evidence requests orally, or if the evidence program, which was intended from the beginning in the opening decision for the main trial, had been followed, then all the witnesses would have actually been summoned. For example, Mr. Templin, who took the money from the house sale, as you just mentioned. The money was there? Yes, the money was there. The money with which Reiner Fuellmich wanted to repay these loans from the sale of his property in Göttingen has been with one of the complainants the entire time. Yes, so one of the complainants, the third in the group, who was not a partner in the so-called Fons GOG, but who also filed the complaint and therefore claimed that it was particularly important to him that his colleagues or this constructed Fons GOG, yes, I can also say something about that. It is indeed very questionable whether it ever existed at all, or whether it would still exist now. We see that somewhat differently. However, the court considers them here as victims or as injured parties, and this GOG fund is now only represented for some time by the two partners who have not significantly influenced the investigative work at all, who have not really appeared since spring or mid-21. They are now essentially claiming the funds here. They are, all three complainants are in the same law firm. This is the law firm, the Hafenanwälte and Marcel Templin, who took the money from the sale of Reiner Fuellmich's house, an amount over 1.15 million, and in this way prevented Reiner Fuellmich from being able to repay the loan from the house sale, as he himself only received about 140,000 euros from his house sale, where there was actually a total of 1.345 million. Yes, he also never transferred it to his two law firm colleagues at any point. That would have been easy. So if, if it had at least been vigilante justice, if they had at least said, okay, we don't trust him, he's going to run away, or whatever stories they made up, he doesn't want to pay the money back to us. That's why we're going to use a trick now. We obtain the money from the house sale, and then Templin does that because he had claimed another loan with a mortgage. There was actually no entitlement anymore, but now it's getting too complicated all at once. Only if he had at least transferred it to his two law firm colleagues, yes. So they are sitting in a law firm. The other two are partners of this GOG fund, not Templin himself. He was only involved in the class action project. And we even declared the assignment in November 23 directly after Reiner Fuellmich was arrested at that time. And this assignment was never accepted. We officially declared it in the criminal proceedings to the two adhesion claimants at that time. They then pursued a so-called adhesion procedure in the criminal process, so they wouldn't have to sue civilly themselves, but instead get everything through this criminal procedure. The damages, that is the so-called compensation. And that was not considered at all. So this Marcel Templin, who is the complainant, obtained the money from the house sale, but he did not obtain it to pass it on to his two colleagues so they could satisfy their claim. No, they simply obtained it like that. They think they could, based on real entries in the land register. There you have the problem again with the obligation contract and the real contract in law. They can keep it due to these formalities, and they tried again at the end of 23 to obtain it from Vivian Fischer, the 700,000 euros, because she also signed the loan agreements, yes, on behalf of the then existing GOG fund. And or they obtain it from Reiner Fuellmich, once again here in the criminal proceedings, or now they have also asserted the claim in the insolvency table, so in a civil proceeding. Yes, no, so they want to achieve it twice, no, so to speak.
It seems to me like...
That's also how Reiner Fuellmich himself sees it?
Yes. It seems to me as if I were to buy a Porsche and I lend this Porsche to a friend, and now the Porsche company comes and says, Mr. Lenz, you haven't paid me the money. It's not in the account and we have to take the Porsche back and so on. And I say, well, yes, a friend has it now, and yes, like that. And then some court case would come up and the judge wouldn't take the Porsche away from my friend. I don't believe at all that this would happen. Any judge would take this Porsche away from that friend pool with a tow truck and deliver it to the other company, I would have to bear the court costs, the attorney fees, the towing service costs, the interest charges, and a hefty fine from Porsche. That's roughly how it would be. And with Reiner Fuellmich, it's not like that at all. No one even looks into it. Oh, so you have an acquaintance, the money is then on it, and well, we'll just leave it there, but now you owe us that. You can't pay it back. For a normal person, that's completely insane, absolutely insane. What's going on there? You can't comprehend it at all.
Yes, especially since we also filed a criminal complaint back then at the end of 23, but it hasn't been pursued to this day. So we have no status on that at all. We haven't received any information on it so far either. And additionally, there are also further claims involved here. For example, there's also the matter of the gold. Reiner Fuellmich also bought gold to secure the money of the previous GOG. They apparently would like to have that now as well. So it's always about arguing that there could allegedly be some tax debts of an unforeseeable amount. But we have already learned in the criminal proceedings that the tax debts have been set to 0. We have also never seen any tax assessments. And what's particularly noteworthy is that the two complainants deliberately prevented this pre-UG from ever being registered in the commercial register NG, and thus becoming the sole debtor of any claims. Yes. Then the personal liability of the shareholders ceases as soon as a UG is registered.
So ultimately, it's probably just about the money, no? Right? So someone wants to have all the money itself, even the gold bars.
That's the feeling we have, yes. That's just the...
But with what right and under what legal circumstances could they get away with that? I mean, it's a law firm. They won't do things that they've whimsically thought up. They'll try to get away with it somehow with the law, with some, I don't know, vague clauses probably. So they must get through with something.
Yes, well, as I said, the problem already lies in the fact that we have a different corporate law perspective than, for example, the court here, and of course also then the adhesion claimants, that is the complainants. First of all, the criminal complaint was filed back then on September 2nd, 2022, on the same day when Reiner Fuellmich was basically also kicked out by Vivian Fischer from the then Corona Committee. Yes, you could really say, when she went public. And in this criminal complaint, quite a few things are described also very, very unobjectively in parts. It was also described that one allegedly felt threatened by Reiner Fuellmich, that he supposedly said he would take the Winchester out of the closet, etc., etc. So the whole thing was described very colorfully, which we couldn't comprehend anyway, to which Vivian Fischer actually also commented within the file that she also found most of these peripheral descriptions ridiculous. But at that time, for example, with the criminal complaint, the corporate documents were not fully handed over. So it was said that they had secretly concluded loan agreements, Vivian Fischer and Reiner Fuellmich, without informing the other two, and without being authorized to do so. And only after Reiner Fuellmich was arrested, almost a year and a half later, did the public prosecutor's office, or I think it was even the criminal chamber here at the district court, finally request the complete documents from the registry court, and then they found out that right at the founding of this company, in the first step, there were already shareholder resolutions where, of course, individual management authority for the shareholders was established and an exemption from self-dealing was granted. So Vivian Fischer and Reiner Fuellmich were allowed to conclude loan agreements, with one always representing the company and the other acting for themselves as the borrower. And in our opinion, they didn't necessarily need the approval of all 4 shareholders for this. The question is whether the inactive shareholders were even still involved in this. Because there were 2 loans that were only issued in 21. The second loan from Reiner Fuellmich was only issued in May 21. when the two complainants had already withdrawn significantly from the broadcasts and were hardly appearing anymore. And they themselves did not take care of the company's affairs, but not even behind the scenes. Reiner Fuellmich, as indicated in an email from November 20, which is also used here to substantiate a side agreement. Back then, he wrote to Vivian Fischer or Tobias Weisenborn, who was one of the witnesses, that he had spoken with Antonia and Justus about wanting to conclude loan agreements to withdraw part of the money from the accounts. At that time, it was about with MWDFG. I hope I got the sequence of letters right.
Yes, that's the one where Bhakti is involved. Mm-hmm.
Exactly, right. There was an interview by an American journalist back then who made this series, Planet Lockdown, and he had then told Reiner Fuellmich that he had just spoken with Professor Bhakti. He told him that they fear there might be account seizures or that the accounts could be closed. That wasn't so far-fetched for Reiner Fuellmich because the Corona Committee's account has also changed 5 times, especially since the accounts were repeatedly closed due to alleged money laundering suspicion reports were without notice by the banks and without explanation, just as it is to this day. I don't know if it has ever happened with Apolut, but
multiple times.
It keeps happening. Yes, so even Off1 is now having difficulties in Hungary, I believe, and continues to receive account terminations. So that is well known. That's a problem that keeps recurring.
It happens to everyone.
Yes, exactly. But the chamber here did not accept that either. So they did assume it to be true, yes, as a reason that Reiner Fuellmich presented here. They were kind enough to assume it as true and not immediately dismiss it as an excuse or a lie. But they then referred to it. They had already mentioned it in previous decisions, and now again verbally in the reasoning of the judgment. Yes, that would be, well, one would have to defend oneself with legal means. Then they could have filed an objection to enforcement or something else. But there is no way. One couldn't take money from the accounts and, in their opinion, transport it somewhere else quasi-illegally or secure it in a property or use it in some other way. Properties could also be seized, and that would not be a valid reason, in their view, under the business judgment rule, or that's a kind of regulation in corporate law, where as a managing director, you have a very wide scope of discretion, which would not be applicable here. They consider it to be fabricated, or they did not see it as a legal reason. And the loan agreements are also considered sham contracts. He should have kept the money liquid in an account, because he mentioned something similar in an email back in November 2020, which from his perspective at the time was supposed to be a temporary stage. Or he wrote something about accounts because he always had the problem that his bank accounts were constantly being closed. That's why he wrote, "I'll transfer it to my wife's account for now. Maybe some of it will also go to the USA." So these were all just considerations, and to now interpret such an email as a side agreement, even retroactively after months, in the end, because the email had been known since I believe the devices had been evaluated from the beginning of 21 and in early May 24, 24, and in May 24 then, while the process had already been running for several months, it occurs to you that from now on only this interpretation variant applies. The loan agreements were void. They were trust agreements. It was a liquidity reserve. And according to this alternative, Reiner Fuellmich is liable. He then made himself guilty of embezzlement because he couldn't repay immediately, but had to sell his house first back then. And then he ultimately wasn't able to repay because the sale price from his house didn't go to him, but rather to one of the complainants. So it's all very contrived.
Did they get that?
Pardon?
Yes, it all sounds like they're catching small fish, small fish to construct a big fish out of it.
Mm-hmm.
That's what it sounds like. Nothing else. What is so dangerous about Reiner Fuellmich that you... What's the deal? Well, Reiner Fuellmich is a likable, very intelligent, very articulate, rhetorically crystal clear person who can attract masses. who does very good work, who delves deeply into matters and so on, who, well, has already brought large companies to their knees, so to speak, as many people know. Now, of course, many people I've talked to are also constructing the Scientology issues into this. However, I don't see it that way at all, because guilt by association is not the same as guilt by ideology, so to speak. That's often how it's taken.
No, he has nothing to do with those people. That's a forbidden reference from the ZF from way back when. Now everything is being dug up to find something. It's quite interesting.
What is so dangerous about him? That's my question. I mean, what could be so could he become a great party leader? Could he uncover the next big, let's say, terrible thing that politicians come up with? Because he was, during Corona, par excellence. He was the number one, if I'm not exaggerating, worldwide in the Enlightenment movement.
I don't know what is so dangerous about him or what makes him more dangerous than others. He is just very determined. He has always stood up for consumers and the common man, as they say, even back then. He went against banks, back then against Deutsche Bank and Hypo Vereinsbank, even before the Corona crisis. That's also why he can't get any bank accounts in Germany anymore, that even his accounts for his own law firm have repeatedly changed because they kept being terminated, and sometimes lawyers employed by him or freelance lawyers had to hold the firm accounts in their names, yes, because it is simply impossible for him to maintain a bank account in Germany for an extended period. And he also spent half the year or several months a year in the USA because he is also licensed as a lawyer there and has this ranch. He's had it for a long time. In this respect, the notion of a flight risk is completely absurd. Yes, and he wanted to go international. He wanted to carry out this class action project, Moderator, for which there have already been several attempts to file lawsuits. As we all know, lawsuits regarding the whole Corona situation are very, very difficult to push through or to win criminal proceedings at all or to have them dismissed. You just described your own case yourself. I don't know if it still has anything to do with Corona, but by now it relates to all sorts of things. So this catch-all clause keeps coming up, the legitimization of the state, yes. And we also know there are constitutional protection reports here from NRW, which you can, for example, access online yourself. It's 179 pages long, the pamphlet, and it was titled How to Deal with So-Called Corona Deniers or So-Called Reich Citizens or the Corona Critical Scene, right? So there are also training sessions for judges on how to deal with Reich citizens or how to handle Corona critics. And I've experienced it myself.
And they certainly do exist. And they exist, sorry to interrupt. They certainly exist for people who are accused of, who allegedly committed incitement of the people or allegedly committed tax evasion, always like Bollweg, for example, right? There are trainings because the woman, the prosecutor, the judge in my trial, the judge suggested, yes, Mr. Lenz pleads for acquittal. What do you think about that, Miss Judge, Miss Prosecutor? She then said almost verbatim, yes, that's not possible because of the Sinn wie alone. And then I looked up what that is. This is now central, a collection point for incitement of the people, hate speech and so on. Incitement of the people is not even mentioned in it. Hate speech and so on. So they are trained there, the prosecutors, and have, this is my claim now, I could be completely wrong, a certain quota to fulfill so that the politicians can say in their records, we now have an increase of 2% in right-wing extremists. We must not allow that. We need somehow more, and so on. This is just a speculation. That doesn't mean I'm saying that's how it is.
Yes. So that, as I said, even we experienced that with this Habeck affair, with the idiot meme. So then a family father with a disabled child is visited in the morning, and he has now also, I believe, been convicted again for incitement to hatred, actually to several thousand euros. So
exactly, he was acquitted because of the idiot affair there. And the judge, the prosecutor, being as cunning as he is, found other things from other tweets. Oh, now he's in trouble for incitement to hatred. So this is how things are constructed in this time. Everything is so constructed. And Reiner Fuellmich is just as far as I see the process, constructed with all possible effort. There was a prosecutor before who had rejected the case. You know that. We all know, you know that too. And now someone like that comes along. And then he's even named Schindler. Schindler is actually a very positive name in history. Yes. Schindler is a very positive name. Yes. And in my opinion, it's constructed and so on.
Yes. It has, exactly. The proceedings were already discontinued in the summer, 2 months before the complaint was filed, yes, by a senior public prosecutor. We have often quoted her because she left a very nice note in the file, where she also explains that it is not the task of the public prosecutor's office to come up with something that might be punishable, but really only to investigate based on, yes, really useful information from outside, or really, yes, serious indications, but not to construct an initial suspicion themselves. And she closed the case back then, and she examined fraud at the time, specifically fraud to the detriment of the donors who gave the money. And afterwards, there was the criminal complaint from the shareholders, who then said that it was not the donors who were harmed, but rather this GOG fund was harmed, which never reached registration and had long since failed as a company because it never got out of this preliminary stage. And ultimately, the shareholders were also completely at odds with each other, and the two complainants ultimately actively prevented the registration. They said, if we don't have any ugly, they then no longer received detailed information from Vivian Fischer and Reiner Fuellmich from a certain point onwards, because they were already completely at odds, and because they also always had a tax advisor with them, whom Vivian Fischer and Reiner Fuellmich already suspected of belonging to the other side or being a spy or informant themselves. And they insisted on having him. Well, okay, this is all getting very detailed now, but they were completely at odds. That's why at some point from, yes, mid 21, it started to become very vehement. And in the end, they more or less parted ways. So the GOG fund never got registered. It never achieved non-profit status. The non-profit status is always brought up here, that it was indeed pursued, which is why the shareholders should not have received any allocations. But it was about a loan here and not an allocation. That must also be distinguished again. Yes. And they were so at odds. They had already presented a settlement agreement back then, the two complainants, and said, we will leave the company on the condition that you give us half of the donation funds so that we can pay potential tax debts. And Vivian Fischer and Reiner Fuellmich, of course, also said at the end of 21, no, we can't do that. We can't give you the donation funds for whatever purpose. The donation funds are earmarked for the purpose of conducting educational work. This work is being done by the two of us, unfortunately not by you anymore. But in that respect, it was never intended and would indeed have blatantly contradicted the statutes and the non-profit status if we had said we would give you half of the donation funds. So there was absolutely no legal basis for it. On the contrary, it could have even been considered a breach of trust at the time if they had done that. Mm-hmm. They didn't do that. And then the other two said, well, then we won't leave the company either. But we also won't give our signature so that it can be registered. So in the end, there was a stalemate. It was 2 against 2. And from this situation, Reiner Fuellmich and Vivian Fischer founded a new UG, which was then promptly registered. It was already registered within a few months by early May 22, and their donation account was then provided from that point on. And yes, this second UG was ultimately also regarded by Reiner Fuellmich as the decisive company. And it must also be said that for the donors who gave the money, it was not at all apparent what the corporate relationships were. I believe I mentioned that at the beginning. They only ever saw that it was a Corona committee. The 2 lawyers are doing investigative work here. Wolfgang Wodarg was often involved. Martin Schwab was often involved, along with other interview partners from around the world. But that there should be a pre-arrangement with these, from the initial setup, was in no way apparent to those who donated the money. And that's why we, as the defense and also the defendant, view this very critically, or rather see it completely differently from a corporate law perspective, saying the shareholders, the donors did not know where they were donating. The first company no longer existed because it was never registered. And therefore, the only ones who could be harmed are the donors. And they do not feel harmed. So Reiner Fuellmich continues to receive 100 letters a day from donors or supporters from all over the world who deeply regret that he is in custody, who cannot comprehend it, some of whom were even present at the court trials. And they say, we have not suffered any damage. We would have even given Reiner Fuellmich our money. He could have bought himself 3 Ferraris with it. We wouldn't have cared at all. He saved our lives during that time. If we hadn't had this Corona committee, then we would have had nothing left. Our own families, friends, etc. did not understand us because we didn't want to get vaccinated because we had a different view on Corona. And this Corona committee, this work helped us to understand the situation. We no longer felt alone, and we saw that there are also scientists and doctors and other experts in Yi who also hold a completely different opinion than the governments. So
if I now, for example, start something within our movement, and I have a large channel and they donate and so on, is there, according to the law, anything stipulated on how I have to dispose of the donations I receive? Am I allowed to buy a schnitzel with it? Am I allowed to? So, as an example, I'm somewhere and eating there, I'm hungry because I live off it. Let's assume I would live off it. Am I allowed to do that? Or does the state say, no, donations are always somehow only for this and that?
Well, first of all, it depends on whether the donations are actually earmarked. So I can specify a particular donation purpose on my website for what people are donating. Here, people mostly just wrote CA or Corona Committee on their transfer slips, or educational work Corona Committee or work Corona Committee. But I can, of course, also define the purpose much more broadly, or specify that there should be no earmarking, or even indicate private use as the donation purpose. In the end, the safest option is to receive gifts, so to write gift as the purpose in the subject line of a transfer slip, then it is very clear. But ultimately, we have also filed the request here to have all the donors, I don't know how many there were, around 20,000, to have them testify in court as witnesses. That's how it was somehow in the process. I don't even know if that actually took place or if a written survey was conducted, but to actually question the donors about what they intended to donate for. And then perhaps one would have quickly arrived at the solution where they would have said, yes, educational work. The educational work was mainly carried out by Vivian Fischer and Reiner Fuellmich, especially by Reiner Fuellmich, because he also conducted these interviews with the international audience, I believe even outside of the Malfoy show. And then there was also this model grand jury. That was also a huge project, this model court proceeding that they conducted on the internet, etc.
Mm-hmm.
And yes. So the two of them, at least those two, clearly did this educational work, and that's exactly what people wanted to see. And this was also reflected in the note from the senior public prosecutor, also at that time senior public prosecutor Reinecke, in the summer of 22, where she stated that exactly what the donors wanted was delivered by the Corona Committee, and therefore there is absolutely no fraud or any damage to the detriment of the donors, namely the financiers. And it is not a corporation at all.
No, I also donate for this and that cause, and I don't care at all what they use it for. Whether they eat something or buy a Ferrari, I really don't care because they do good work and that's it. It's the same. With normal people who work somewhere, they get something. And some get 6,000, some 8, sometimes 2,000, and one buys a house, while another unfortunately can't buy one, whatever, and then it is just the way it is. So, for me, it all sounds very contrived. What happened with Reiner Fuellmich in Göttingen, I hope that if you go into appeal, it somehow gets better, more truthful. Do you have what outlook do you have when you think about the appeal?
Well, the appeal is initially a purely written procedure, which is very formal. The aim now is to challenge the verdict or the process, both in substantive terms and formal terms, so that we can find formal grounds for appeal, ideally also absolute grounds for appeal. For that, we have to wait for the written verdict, the reasoning of the judgment, and then see, we already have quite a bit regarding the procedure. As I mentioned earlier, the flawed and completely excessive written procedure, for example, and that our evidence was rejected, the witnesses were no longer heard, etc., or only on very limited questions. So all of this can be challenged in the appeal process. After that, there would be a second instance before the regional court. The appeal process is essentially just an interim step. And then there will be the same process as now, but before a different chamber at the Göttingen Regional Court, where one can only hope that it goes better with a different panel. We also have the additional burden that we are now expecting a second criminal trial before the same chamber regarding the monthly payments. So charges were also brought back then regarding these monthly payments to the Fuellmich law firm for communication work. And the regional court here even rejected them. So the opening was clearly rejected by the current chamber. Then the prosecution filed a complaint with the higher regional court, and about that, for example, it was also kind of a joke in quotes, because it took forever to be decided. It was only at the beginning of November last year that there was suddenly a decision from the higher regional court of Braunschweig that the second trial would indeed be opened. And we had received interim decisions in the meantime, that is in the detention complaint from the higher regional court of Braunschweig. They were really, you could see they attributed emails from Vivian Fischer to Reiner Fuellmich, where she had written that she urgently needed money privately to justify that Reiner Fuellmich was in a financially precarious situation. So they really mixed everything up, and this court then decided that the second case regarding the monthly payments will also be opened now, which is why, unfortunately, we also have a second criminal case before the same chamber. We now have to face in the end. So that's really bad.
So that means the same judge, right?
Yes. Same lineup, yes. As of the current status, we are checking if we can still change that somehow, because we have also filed a very, very large number of bias motions during this process, all of which were rejected. We have consistently filed detention review motions, but also a lot of bias motions, some of which were even rejected by the chamber itself because they were deemed inadmissible. Yes, that's all about that. And the really precarious thing was, on the very last day, that Thursday, when the verdict was then squeezed into the evening, I still had a deadline that afternoon to justify a bias motion by 4 o'clock. And at 3:45, Roger Bittel suddenly called me, and some other trial observers who are also press people contacted me and informed me, oh, the verdict is supposed to be announced today at 5 o'clock in the evening. We just got the information from the press office of the district court. How can that be when you're still sitting there and justifying motions for bias? So it was obvious, at least one could come to the conclusion that it was already clear that this motion for bias would, of course, be rejected again. So although it wasn't formulated quite so clearly, it was left vague, but it's certainly strange that the press is already being invited while the lawyer is still sitting there justifying the motion for bias. So as I have to say, I've never experienced anything like that. So I knew something was absolutely not right here. And then we had a brief moment of hope because we thought if they squeeze the verdict announcement into the evening, then maybe it will lead to the arrest warrant being lifted, because that would have been the only reason from our perspective, Gorka, for announcing the verdict so quickly on the same day, that the arrest warrant would be lifted and they would have to release him as soon as possible. But that didn't happen either. They just squeezed it into the evening. I don't know why. Maybe because they wanted to finally finish the trial because they were going on vacation the next day, or maybe they wanted to raise hope again for the defendant, Reiner Fuellmich. I don't know why it had to be rushed through that evening.
We've been talking about Reiner and the trial this whole time. My last question to you is, how does it feel as a lawyer who has passionately and vehemently pursued this case and draws such conclusions from it, along with many other insights that we won't mention here? How does it feel as a lawyer?
Yes, it is indeed. It is very exhausting. It is very draining. I can only say that. So at some point, your nerves are on edge, or rather, this negative feeling that that at some point we naturally also thought that we finally want to have this trial over with. But regardless of that, the fighting spirit was always there. So at least I always had the hope that it can't be. We must somehow be able to convince them of our legal views. That's why I also read many documents from the file. So I didn't just give a plea. That was also criticized by the chairman. I hadn't given a proper plea. Even the defendant himself supposedly said that it wasn't a proper plea. I had read out irrelevant documents. I read out things that also concerned the prison, where the conditions were very, very harsh. Yes, he was isolated from the other inmates for months. He was finally able to be examined by a doctor of his choice at the beginning of March because he had severe problems. He wasn't allowed to exercise. The nutrition is very poor in the prison, including the vitamin supply, etc. They are only allowed to be in daylight for 1 hour a day. And as I said, he was completely isolated for months, not allowed to speak to any fellow inmates. On the contrary, the fellow inmates were also threatened with punishment or isolation if they dared to greet him at the window, as he reported. And all these aggravating circumstances, which should have been relevant for sentencing, in my opinion, and should have been considered as mitigating factors, are the reasons we presented them. And that was also the reason why I read out documents. For example, I also submitted many legal arguments before the start of the main trial. Many written submissions where my former colleague Schön and I still thought we could prevent the opening of the main proceedings by clarifying everything in writing beforehand. I naturally read them out later as part of my plea because I don't need to draft a plea twice if I've already dealt with everything legally. So that was also held against me. It was then said that it wasn't a proper plea. I was somehow only allowed to present something orally from memory. And I did that in the last few days, but that was also rated negatively. So that, yes, so I really felt at some point that I was talking to a wall, to a barrier. Yes, you can't get through. So, and that is quite frustrating.
Mm-hmm. Katja, thank you for this conversation.
You're welcome. You sound exhausted.
No, I'm not exhausted. No, not at all.
I mean, like, as if this topic sounds exhausting, you know? Unfortunately, because it has so many negative aspects.
I am personally very frustrated with this legal system. Now I'm speaking privately. This has nothing to do with your opinion, only with mine. I am tired of this legal system that is no longer a legal system. I no longer perceive it as a constitutional state, but I believe that it has now become a political legal system that somehow has to accommodate the habits of the government. I don't want to say the entire state, that would be an exaggeration, but the government somehow. And for whatever reasons, People are being denounced. People are being brought into a trial. Now, I'm not saying into prison. In Reiner's case, it has happened. In Bolweg's case, it doesn't seem to be happening. But to be nailed with legal proceedings, so that the Enlightenment movement or the democracy movement, the peace movement, it affects all movements, so that they are worn down, because we will have a different formalism in government and also in the state in the future. That's the impression I have. Corona was just the beginning. That's how I see it. I don't have to say anything, so I don't want to put you in a tricky situation as a lawyer. That's not my intention. That's why I say that's my opinion on it. And I'm fed up with these fabricated trials, that there are people who do a lot. I was born in 1962, grew up during the beginnings. Never again war. Do something against fascism, against totalitarianism, and against any form of dictatorship. And you can't take that out of my generation, at least not out of me. And the time I'm currently living in for about now, I've actually been experiencing this in the peace movement for much longer than the Corona people, because they have experienced it too, but only on a small scale, on a very small scale. That didn't really reach the public through the Corona movement and through the Querdenker movement. It has become huge in the civil society, that suddenly lawyers are in the movement who are interested in these people, that there are trials, hundreds of doctors who didn't vaccinate, or doctors who said, don't use an FFP2 mask. I learned painting and varnishing, right? I often wore an FFP2 mask, and I also had these training courses. I painted cars in protective booths with a proper, you have to prescribe something and so on. No one needs to explain to me what an FFP2 mask is. Yes, an FFP2 mask has gaps that are as big as a penalty box, like a soccer goal, where I can shoot a mines ball through without a net. That's the virus that comes through these grids. So the idea that an FFP2 mask protects against viruses is complete nonsense. People who work in such high security workplaces with viruses, they have full body protection, complete with helmets, and look like astronauts. Those are the things that protect against viruses or bacteria, not these things. So this construction and this participation of the population, and not wanting to understand what is really happening, even though many went through the same school as I did, right? We all did. In 1962, that was shortly after the war, basically. That was, right? So, and my parents are refugees themselves and so on. Everyone can tell their stories, right? And it's simply unbelievable what's happening here. And of course, this also includes the process of Reiner Fuellmich. It's unbelievable. And Reiner also mentioned this in his closing argument, if I just imagine this Cum-Ex affair, where there was now an 8-part series on ZDF, where everyone can roughly see what the strategy was and what damage was done. So in billions, in an enormous amount of billions, tax money was simply siphoned off twice, knowingly, and so on. That was just one trick by lawyers who did something with the banks, and nothing happens, right? Everyone knows that the Chancellor is certainly a minor figure in the Cum-Ex affair, but still, such things should also be pursued. Such things truly belong in a courtroom. But these people, and you notice more and more in this country that these people, or that it's not all migrants. You absolutely must not generalize, but there are some migrants who are here with knives, who rape here, who form gangs and so on. And I always think, are they crazy not to take this seriously? What is that? Someone like Reiner Fuellmich gets 3 years, 9 months, and the probation is not counted for 5 months. So he gets over 4 years. And someone who rapes women and kills small children usually gets probation. Not as a German, but if he is a migrant, then that's just not right. That's just not right.
Yes, but also as a German in cases.
Yes, indeed.
So sexual offenses or any crimes against physical integrity are very often met with probation sentences for first-time offenders. Yes, basically answered. And here we have an economic crime where you could say it's only about money. Yes. So I really find that a qualitatively very significant difference. And then we have here at most, if you were to somehow twist it, yes, then we would have here a conditional intent and a risk to assets. Yes. So you probably have to justify it somehow. But we have no financial damage, no intent from the beginning. We don't have any trickery, etc., where someone, as you already mentioned, constructed some kind of anti-rule of law model from the start, and he intended to repay. We have a non-profit background here, an educational effort, something very idealistic, yes, where someone or where two people worked who had high ideals and acted according to their convictions. And this is equated with people who really only had the intention of enrichment, or even punished more severely than crimes against physical integrity. Absolutely.
And I don't know if we've already talked about this. I was a therapist at the J.A. Hammond, so in juvenile detention, in juvenile correction, so a juvenile institution. We have here in Hammond the largest juvenile prison in Europe. And I was a member of the anti-aggression training and was then involved in therapy work and developed my non-fighting principle from this work. So I'm aware that these people get probation. We receive files on them that are really this high, So the files for each youth are 50 centimeters high, and they have committed between 100 and 800 offenses, physical, violent offenses. This includes rape, sometimes even multiple murders, homicides, and so on. Some are just bodily harm, but very brutal, and so on. I am well aware how things proceed in court and how it goes in prison. I know all these things. By the way, they have great food. There they have a 5-star chef. The federal president visits once a year. It's a showcase for judicial work in Germany, resocialization, and so on. So they have top-notch things there. Yes, but unfortunately, not for Reiner Fuellmich.
No, he's in a high-security prison and was brought to court with ankle and handcuffs like a terrorist. Yes.
The law-abiding citizen only knows that from the Hannibal Lecter movies. From such people like real mass murderers, however, and people who cannot be rehabilitated, in such prisons. Well, Katja, thank you for this conversation.
You're welcome.
This was another edition of Empathy Today with Katja Wörmer. This was a production by Apolut. With us, you mainly hear voices that do not get a chance to speak in the mainstream because they also belong to the spectrum of opinions in a democracy. Apolut is independent of advertising clients and broadcasting fees. Only your support makes our program possible. Thanks to your commitment, we can provide our content for free. All information about Bitcoin and bank details can be found at apolut.net/support. Feel free to share our contributions with your friends and colleagues to strengthen our reach. If you don't want to miss any future contributions, you can subscribe to our social media channels and our newsletter. More information can be found at apolut.net/newsletter. Thank you for your support. Apolut. Now, more than ever,